So let's start way back, and I promise to fast forward. So in 1925, Congress enacts the Federal Arbitration Act. And the idea behind the statute, every reasonable legal historian will tell you, is that Congress wanted to promote arbitration between equally sophisticated businesses, so that then instead of going into litigation and having sort of acrimonious, time-consuming, expensive litigation lawsuits, businesses could continue to work together and have these arbitrations over disputes. And the arbitrators were often taken directly from these business areas so that they had some expertise, some background, and that would presumably make things run a little more smoothly, a little more quickly. And for 100 years, the idea was that arbitration was really, first of all, something that you entered into with full consent. So sophisticated, equal business entities would negotiate for contract for arbitration of certain disputes. Second, that we were using arbitration in sort of very niche areas like labor, complex commercial interactions that might require sort of the knowledge base of an arbitrator. And then it was not the sort of thing you would just sort of foist onto the unknowing person. And the Supreme Court upheld this view for many years. And one other side note, the idea was it's the Federal Arbitration Act, and so it would apply only in federal court, right? The idea being that we have a federal system, and federal laws don't necessarily and always, especially when they're not constitutionally grounded, apply to state proceedings. And then we get to the 1980s, and everything starts to change. Everything starts to change in the country politically, for sure, and I think that's part of the story here. The country grows more conservative, more business-oriented, and there's a concern among lots and lots of people about a litigation explosion, that there's just too much litigation, that everybody's suing everybody for everything. The empirical studies show that this is completely false. This was completely made up. It is true that there are some there's an uptick in lawsuits if you control for population. However, not anything significant. What is really true, though, is that in the 1960s, Congress enacted a spate of legislation that gave lots and lots of people rights, federal rights that they could pursue in federal court. Most prominently, I think, Title VII, which gave women, minorities, the right to bring lawsuits in federal court alleging discrimination in employment. That causes some increase in litigation. And so really quickly we see in the 1980s lots of efforts to reduce the amount of lawsuits being brought against big businesses. And there's a whole other video that should be done on tort reform efforts and the way that we've sort of cabined the ability of ordinary Americans to get redress in courts. But one sort of, I think, stealth move was to breathe new life into the Federal Arbitration Act and to basically engage in a reinterpretation of the statute, an interpretation that I think is a 180-degree reversal from the Supreme Court's earlier decision-making. And so we start to see some decisions in the 80s pulling back on this idea that arbitration is really only between two big businesses, that it's consent-based. And finally, in 2011, the Supreme Court, I think this is the watershed decision, in AT&T versus Concepcion, a standard form contract, the kind we enter into every day, all of us, includes a forced arbitration clause and a class action waiver, and the Supreme Court upholds that provision, despite the fact that California law prohibited forced arbitration clauses and class action waivers as a matter of public policy. So there are two things about Concepcion that I think are important. First, we see that no longer is consent important. Because we all know we don't really enter into these contracts with full consent. We're not really reading through and understanding and agreeing to every single provision in the contract. Second, we see this being used against consumers, right? This had been a big no-no, right? Because again, we don't have that sort of equal bargaining power. And third, the state had a policy, California had a policy that class actions were the only way that consumers could vindicate their consumer rights under California law. And the Supreme Court says the FAA preempts that state law. 2 years later, in a case called American Express versus Italian Colors, this is a federal antitrust litigation brought by small businesses against American Express, alleging that, I don't know how many people know this, that American Express is actually quite an expensive card for small businesses to take. They charge more. And these businesses, all of them relatively small businesses, sued American Express for antitrust violations under the Sherman Act, alleging that the swipe fees were, super competitive, to use the language of the economist language. But each of the merchant cardholder agreement contracts contained an arbitration clause. And so American Express moved to compel arbitration of this class action. And also there was a class action waiver. In other words, every merchant would have to go into arbitration individually. Any individual merchant trying to arbitrate a claim against American Express, let's say your claim is worth $1,000, you'd spend orders of magnitude more than that to try to prove an antitrust violation, because you need to hire an expert, you need to do a lot of discovery in order to get that claim off the ground. So clearly, compelling arbitration in this case would basically kill the case, right? Nobody could actually arbitrate the claim, but that's exactly what the Supreme Court did. They compelled arbitration, and despite the argument, which I think was forcefully made in that case, that the arbitration clause prevented these merchants from vindicating their federal statutory rights. Since then, the Supreme Court has decided 14 cases upholding arbitration in various contexts, including the nursing home context. So, for example, I bring mom into the nursing home in the middle of the night because she's been wandering around with the Alzheimer's. I quickly sign forms, even though I may not even have power of attorney. If mom later wants to bring a negligence claim for some action at the nursing home, she's bound by the arbitration clause in that original contract. We've seen it in all sorts of consumer contracts. We've seen it in employment contracts. The court seems there's no arbitration clause at this point that the court doesn't think should be fully enforceable on its terms. But for the most part, the Supreme Court has given tremendous cover to arbitration clauses, and I think companies have kind of run with it, right? It's a green light. What more can we stick into this arbitration clause, and let's see if it sticks. And most people don't want to litigate these arbitration clauses. So lawyers I talk to regularly tell me that they get people into their office and they talk about, they tell them these horrible stories, and the lawyer says, well, did you sign an arbitration clause? And if they did, they just don't take the case, because it's not worth it to bring a claim in arbitration for most attorneys who want to make a living. And since you can't bring it as a class, since it can be very difficult to get discovery, since the outcomes in arbitration tend to favor the more powerful party, these are cases that are not worth bringing, and so lawyers are sort of letting these cases go, and they're really just slipping through the cracks.